Hi everyone, my name's PK, and here I have Ritchie Muir from Lawlab. He is a solicitor or lawyer, and in this episode, actually, I've never had a lawyer or solicitor on my channel before, so it's going to be like a new thing we're going to discuss. We're going to go over basically all things, or the most important things to do with the legal process of how to buy a property. So, like, the best clauses to put into a contract in that sort of special conditions box. We're going to talk about different states have different processes, like WA has I would say, much more conservative process than other states, so how not to be tripped up. There are like some real horror stories about how people like just get the legal process wrong. So Richie's going to take us through like kind of his best advice on how to avoid that. And just in general, if you're new to property investing, he's just going to help you, I guess, overcome those nerves, so to speak, and just like be confident in that legal process. I always say, to build a team is really important. You need a conveyancer or a lawyer, you need a mortgage broker, you need a building and pest inspector, you need property managers, etc. So obviously Richie as a lawyer is a key aspect of that team. So thank you for making time, Richie, and good to have you here.
Thanks very much, PK. Pleasure to be here.
Also, maybe we'll just take us on a bit of a background of like your, I don't know, your professional history. I don't know if this is right, but I was just stalking you on LinkedIn before, and I saw you went to QUT. If that's true, then I won't hold you against it. But
Well, my background, I was born in Australia, but grew up in Europe, so Malta, England, and then Scotland. So I went to University of Glasgow,
Right.
and did my law degree there. And then I came back to Australia and did a conversion course at QUT. So that
Right.
was essentially topping up a sort of Scottish law degree with some Australian subjects. So that was back in 2006. So yeah, I've been practicing law in Queensland and Australia nationally for the last 15 years or so. And I'm a legal director at Lawlab now, and we're a national property law firm, which is quite unique in the sense of there's very few, I guess, property lawyers specialising in conveyancing on a national basis. So we cover every state and territory in Australia.
But what do you think that is? Like, this is just like a off the script question. Like, you're kind of unique. There's you could probably count on one hand how many national conveyances there are that operate in all states and territories. Why do you think like, well, why did you go down that route? And like, why do many firms don't do that?
Well, it's kind of like dealing with 8 different countries, particularly with property law. Every state and territory has, their own set of property laws and conveyancing practices. So it's not just the laws, but it's how each state and territory deal with the practice of conveyancing. And then it's also the delivery of conveyancing as well. In some states, it's exclusively done by lawyers like Queensland.
Yeah.
But in other states, you have both lawyers and conveyancers who deliver conveyancing services. And in other states, they call it even something else, like in WA, they call it settlement agents. And often the scope of work and what each legal professional can do differs between those states. So yeah, it's difficult to set up a conveyancing business that deals with every jurisdiction, but we've been doing it now on a national basis for well over 10 years, and we've got a big team who specialise in each of those jurisdictions. So it's
Nice.
not easy. It's been a fun journey to get there.
Yeah. And also, sorry, this is a bit of a cheeky question, but it's like an honest, it's well-meaning. Like how lawyers, even accountants, it's like a very, on the face of it, it's like a very quote unquote boring profession. I'm sure like once you get into the nitty-gritty, like in anything, you find a lot of joy, I would assume, like
No,
in
yeah.
in what you do. Is that true? Or
Well, I don't think anyone's ever said conveyancing is sexy.
yeah.
But it's often an underrated part of the buying process. And we like to think of it kind of like, well, we think consumers should think of it like insurance. Most of the time, the transaction will go through smoothly, but I guess like insurance, you want to have the best insurance, but pay a reasonable price. You want to be covered in the event of something going wrong. So that's, where we're involved is we know what to look out for. We know the risks. We manage the risks for you. And, most of the time, it'll be a straightforward transaction, which is great. But, buyers and sellers need to have someone there who can look out for those risks and protect and make sure that they're buying what they mean to buy, and they're protected.
Right. Well, I remember when I bought my first property, this was more than 10 years ago. The conveyancer navigated me on the contract of sale. It was in New South Wales, to the special conditions box. And they sort of said, look, this is where you can put in basically anything you want, as long as it's worded appropriately and reasonably. And for me, that was there's not just a standard contract. Everything can be negotiated, from fixtures and fittings to how healthy the house is and sort of its structural stability, even when settlement occurs or exceptions. So there's you can put, I remember that first property, I think I had an addendum to that special conditions box, as everything couldn't even fit in there. But ever since then, I just kept refining that. And that was, for me, and part of the conveyancing process, for me, that special conditions box is one of the most important things. And we'll talk about the process at a more macro or broader level, but just to kind of zoom right into that special conditions box, so to speak, or just clauses in general. When someone, a new property investor or even an experienced property investor, is putting in an offer, they're giving that contract to the agent. What are the clauses, or what are some clauses apart from just the building and pest and finance that they should be considering, at least to make sure that that deal is in their favor?
Yeah, so you're right. So most jurisdictions have a standard form of contract. And that's just to enable, the transactions to happen relatively quickly. So the real estate institutes or law societies will have a standard form of contract, and that will enable a lot of the sales agents to complete that standard form. But drafting special conditions requires a legal practitioner. So a lawyer or conveyancer can only draft special conditions. An agent can use a special conditions book that has been prepared by a lawyer, for example, and copy paste those in to contracts. But all contracts fundamentally are negotiable. So as a property investor, you can negotiate whatever terms you want to, but there's still market forces at play here. You need to understand that you can't expect that everything you ask for will be agreed, and you've got to consider, well, what competition are you up against? Are there other buyers who are interested? A seller and agent are more likely to accept a more vanilla offer, from another buyer, than a really complicated offer from one buyer. So you need to bear that in mind. But some of the fundamental special conditions you would use if you need to, and there's no point in using special conditions for the sake of it. You use them when you need to, but so it may depend on the transaction type or property type. If you're buying an existing property, one of the big things I always say is, well, have there been any works done to that property since it was originally built? Has there been an extension? Has there been a carport constructed, or a pergola, or a large shed, something like that? And if it has, do you know if that's been approved? And do you know if they've had the final certificates? And a lot of the time, you can only get that information from the council. And that can take time, and you may not have time to find that out before you go to contract. So therefore, a due diligence special condition is very useful in that regard. And due diligence usually will give the buyer 14 or 21 days to undertake due diligence investigations about the property. And if they're not satisfied for any reason with the results of those investigations, they can pull out of the contract and get their deposit back. So that's a very good condition to use, the property investor. It gives you, it's kind of a get out of jail free card, and can extend to pretty much everything. But of course, sellers and agents will understand that, and they want the contract to go unconditional as soon as possible. So if a property investor does get any pushback with a due diligence special condition, they might want to refine that, and based on what concerns they might have. So In that example before, if they thought that there'd been an extension, they weren't sure about the approval, or whether it had been constructed in accordance with the approval and had the final inspection, they might just have a special condition saying that this contract is subject to the buyer confirming that that the approvals are in place, or that the satisfactory council records are obtained. So things like that.
Yeah.
So that's probably the biggest special condition that we recommend, is a due diligence or refined version of due diligence.
Yeah, right. I mean, the number of times that you see people buy a property, and it's not a bad thing, that has like an unapproved carport or anything like that. And honestly, it might not even matter. No one might pick up on it forever. But if in case you have one of those neighbors who does, then that's like a whole hassle to go through that process or have to take it down. And you just don't want to be caught in that lurch.
Well, I mean, I think there's something like, stats say 30 to 40% of all properties in Australia have some kind of unapproved structure on them. Either unapproved itself, or it's been constructed not in accordance with the approval that they did obtain, and hasn't had the final inspection certificate. So that, that's, as you said, may never be an issue, but it very well potentially could be, because usually most insurance policies require you to disclose to the insurers whether there are any unapproved structures, or there's a positive obligation to say that this property, has all the approvals.
Yeah, right.
And that will be in the fine print somewhere. But of course, then there's been there was a major incident in Brisbane a few years ago, where there was a party at an old Queenslander, and on a deck, and the deck hadn't been approved, and it collapsed and people were injured. So in that scenario, the insurers will be asking questions about the approvals. So it is important to check that stuff out.
Okay, cool. And do you have like any stories or any anecdotes of, like, I suppose, the biggest failings that your clients or people that you've heard of, investors or property buyers, have experienced because they haven't, not just regarding these special conditions, but just regarding the whole conveyancing process in general? They haven't understood it, they haven't done it right, they've maybe worked with a dodgy conveyancer. What are things that could go wrong, generally speaking, throughout the process?
Yeah, well, yes, there's been a lot of examples over the years, but the first one that comes to mind is and it sounds basic, but actually inspecting the property before settlement. So we had a client who, despite us reminding them to do so, had gone on conditional, and then hadn't sent someone round to inspect the property pre-settlement. And this had been tenanted, and they were planning to move in as owner occupiers, but wasn't inspected. And when they settled and got there, and saw the state of the place, and it'd been left in an absolute mess. So there was, bed bugs, and there was cockroaches in the kitchen, and there was just, nobody had, cleaned up. And usually the contracts require the property to be in the same state of settlement as it was at the contract date, with a bit of fair wear and tear accepted. But because they hadn't inspected it before settlement, they were left with this property in a really terrible condition. There's been other examples where people just rip stuff out, and taken it with them, or just dumped it in the garden. They haven't tied it up. So that's a really important thing to do. And if you're an interstate investor, then think about getting someone local around before settlement and checking it for you. Whether that's your intended property manager or someone else like that. It is really important to do that before settlement, because if you leave it till after, and the seller's been paid their money, it's very difficult to get damages after that. In that example with our client, we did manage to recover some money from them as compensation, but there's a bit of a process, and it can end up costing extra in legals to do that. So that was an important lesson for that client.
Right.
Another funny example, well, funny in some way, it ended up all right in the end, but a client bought the wrong property. So there was a duplex, and it was a developer was selling, and it was like 1 and 1A, and they'd gone to inspect it with the agent, and they thought they were buying the property on the left, and the agent had assumed, okay, well, that must be lot 1, so the contract was signed, all the searches were done, the plans were done, provided the plan, oh yeah, that's lot 1, et cetera, and then ultimately, after settlement, when they got their keys and they went, well, this key doesn't work, and then they realized it was they bought the wrong house, it was next door. So fortunately in that situation, we're able to unravel that, and end up getting the property, and there weren't too many complications, but just everyone involved in the transaction, missed that. But really, it was the importance of that is the client, checking those plans and letting, and really letting the lawyer conveyancer know, well, which property is the one they're buying. Because the legal stuff was all fine, the contract matched everything, but it's up to the client to really check those kind of things.
Yeah, I guess that's also kind of extrapolating that point a little bit further as well. It's important not just to blindly trust, I guess, everything that the real estate agent is saying. There's some fantastic agents out there as well, so credit where credit is due, but they can make mistakes, or they can kind of stretch the truth a little bit as well when it comes to easements or things like that. So it's really important to get a conveyancer to actually, if it falls within that realm, to actually check all those things in the searches. And I might just touch on searches for a second. In the conveyancing process, Richie, as you know much better than I do, there's various searches that happen to basically form your due diligence of that property. These searches involve talking to or getting records from council, things that I couldn't really do that easily myself, but a conveyancer or a lawyer is more appropriate to do those.
Yeah.
What are those searches? Like, I know there's like lists of them, there's dozens and dozens of dozens, but what are like the major ones?
Well, it depends on what state for a start, what jurisdiction. There are some jurisdictions in Australia where there's a vendor disclosure regime. So, for example, in New South Wales, and even more so in Victoria, and South Australia and ACT, the seller must disclose a whole bunch of information about the property, and this is prescribed in legislation. So they call them prescribed documents in New South Wales, and Section 32 vendor statement in Victoria, the Form 1 vendor statement in South Australia, and the ACT as well. The ACT goes as far as requiring the seller to provide a building and pest report attached to the contract disclosure. So those states, there's a good amount of disclosure. You need to make sure that's up to date, but there may be additional searches that the buyer wants to do. Those council building records for a start, or any outstanding notices about the property. And then on the flip side, in the other jurisdictions, Queensland, there's relatively limited disclosure from a seller's point of view. For units, there's a bit of disclosure, so about the levies and things like that. And off the plan, there's a fair bit of disclosure, but for existing properties, it's quite limited. And that's the case as well, very similar in WA, NT, and Tasmania. So for those jurisdictions, we would recommend a bunch of searches, and with our search, so we obviously send out a search form for clients, but we explain when they might need searches. So rather than just having a list of 20 searches, and the buyer being left to consider, well, which one of these should I get? Because of course they all have a cost to them.
Yeah.
And if you were to order them all, you could end up spending thousands of dollars. So you really need to consider what searches are relevant. If you're buying a house, that's near a main road, you might want to do a main road search to see if the council or the state are planning to resume or widen that road. Because if they do, then you could lose your property. Yes, you'll be compensated for it, but it's the last thing you want to happen. So a main road search, or if there's a recent subdivision, on, maybe it's been on previous farmland or near a petrol station, the land might have been contaminated. So a search of those records, or if you're buying a really old house, checking on the heritage register. But the most popular searches we find our clients doing would be the council records to make sure that the approvals are in place and the final inspection certificates are in place. And for anyone buying units or townhouses, a body corporate inspection records. That's if you were to do nothing else when buying a unit, you should be ordering one of those, and it can cost $400 to $500. But that involves a strata inspection agent actually reviewing all the records, so all the minutes of meeting from the AGMs and committee meetings, and looking to see if there are any issues. There might have been defects with the common property. The building roof might be leaking, or there might be repairs that are needed to the swimming pool. So as a buyer, you'd want to understand what they are, because they can turn into big costs and shared by every owner in the body corporate. And you'll usually be able to find out if any special levies have been struck as well. And you often find that a lot of people sell units and townhouses before they have to pay these special levies. So it's really important to know. And it's not, and because it's a decent cost, it's not something that we say is compulsory. It's highly recommended, but it's up to the buyer to decide whether they want to invest in that. But as an investor myself, I would always spend that money on getting an inspection of the body corporate records.
Yeah, right. I mean, especially if there's a elevator or swimming pool, like you said, or tennis court or anything like that. Oftentimes, as you know, there'll be from the body corp, there'll be a projection of like future intended costs, and if there's nothing left in the sinking fund, then you know that someone's going to have to pay for it, and it's probably going to be
absolutely.
So it's a really good call out. You did mention, or you did touch on the kind of nuances state to state. I thought we'd just dive in deeper for a second on how in WA, to get out of a contract once you've gone conditional, it's almost impossible to get out of that contract, for example, on the building and pest inspection clause, whereas in Queensland, it's very, I wouldn't say very easy, but much easier, so long as you have the right clauses in there, especially in the special conditions box, as we were talking earlier. Could you kind of further expand on sort of how the regulation or the legal structure in WA is different? And is it just WA, or are there other states as well that are a bit like that?
Yeah, I mean, ultimately it comes down to the contract terms. So in WA, you'll find that there's a very, I guess it's industry standard structural defects special condition and pest special condition. And so essentially, unlike Queensland, where a building pest condition, the buyer must act reasonably, but really if there's any kind of defect, then they can terminate the contract. That's as long if it's not satisfactory to them acting reasonably. And what is reasonable? It's very difficult to prove that someone's being unreasonable about something. Maybe if it was a leaking tap, okay, and you terminate a contract, maybe that's being unreasonable. But if anything that could incur a significant cost, it would be reasonable to terminate a building contract, a contract based on the building and pest condition. In practice, you'll often find that there'll be some negotiations about that, and ultimately the seller may agree to fix defects or even reduce the price to cover the cost of those defects. Whilst in some jurisdictions like Western Australia and Victoria, those building and pest conditions usually are limited to structural defects. And then, of course, you may need to get, the building inspector, you need to get a licensed building inspector to confirm whether or not they're structural defects. And often there's dispute about that as well. So it can be much harder to terminate contracts in WA and Victoria because of those special conditions, but don't assume that's always the case. You do need to check the actual terms of the contract, the special conditions of the contract. And that's where your lawyer, a conveyancing lawyer, a conveyancer should be advising you on that.
Yeah. I mean, there's plenty of people that I know that have bought in Perth over the last number of years, and they've actually put in special conditions and been able to negotiate on the back of building and pest inspections, even if there hasn't been major structural defects. But by and large, as you said, and I just want to pick up that point because like how objective or subjective is that? So for example, if there's like a crack in the wall, and I, as the buyer, say it's like a huge structural issue, but the seller is saying actually it's not a crack in the wall, it's just cosmetic, it's around the paintwork, it's just around the plaster. How do you, as a legal professional, how do you figure out what the truth is? Like, do you have to get an engineer in there, and do they have to write a report? Like, what's that process?
Yeah, you've hit the nail on the head. It's a common cause of disputes, particularly in WA. And often you can go around in circles with this. So ultimately, what is a structural defect and what isn't, needs a licensed professional, a structural engineer, to confirm that. And we've had to engage them in the past. And of course, there's a cost associated with that. So these things need to be considered in the context of, the extent of the damage and cost to rectify. But structural defects can be very costly to rectify. So it may be worth paying for that advice from a structural engineer on that one. But the better way to deal with this, of course, is not to, as a buyer, to get your contract reviewed before you sign anything. And ideally we can negotiate a broader special condition that isn't just limited to structural defects, and potentially even a due diligence condition, so that you don't have to dispute whether or not something is structural or not. Ultimately, if you're not satisfied with something, then you can pull out the contract.
Yeah. I think that's wise advice. It's always a bit of constructive friction in terms of, like, in a really hot market, do we really have that luxury of doing it? I would love to do it. There was a recent case of actually a client of mine who, I don't know this either, it was a learning moment for me, where the garage was not attached, it was a detached garage. And that actually had a small, like a 1 centimeter crack. It wasn't huge and it was detached and it wasn't a big deal. But because it wasn't attached, it didn't fall into that strict category of major structural defect. And so she couldn't actually exit the contract, or there was no repercussions on the seller because it was detached. She still negotiated, and she still got some money off it to be able to fix it. But that was just probably because she was a really good negotiator. So there's all these nuances and kind of like sub caveats and things that it's just impossible for like me to know. So it's really important to see a conveyancer or a solicitor, I guess, for that. And
yeah, I mean, the other thing, if the contract was still conditional upon finance, there might be a question. Well, would the bank, if they're aware of a structural defect, would they approve? Would they accept this property as security for the loan? So that might need to be investigated as well at the time as a last resort.
Right. So in that vein or line of thinking, maybe in some instances, I don't know if you'll disagree with this, Ritchie, maybe it's good to have the building and pest inspection done ASAP as soon as you exchange contracts, and then have your finance clause a little bit further out, so you've got like that stopgap, another sort of thing to fall back on. Have you
From a buyer's perspective, yeah, that's correct.
And just before,
and listen, most property investors, would probably want to get some kind of pre-approval at least,
of course,
before they put offers in, so that they'd have that comfort that they're not overextending themselves by signing a contract. And then, there's a cost to investing and buying property, and I think it's a reasonable to have that, to pay something to get a licensed professional to check out the property and see if there's any issues with it. And even if you ultimately don't end up getting finance approved for some reason, at least you haven't bought a lemon in the end. So it's an investment in the property.
Yeah, no, for sure. Get your finance. Have a really good engagement with the mortgage broker before you put in any offers in. That's obviously very important. And just before we wrap up, I thought I'd just ask you this, more of a macro and overarching sort of thing. I mean, you've been doing this for a long time. You've been running your business for a long time. You've probably dealt with thousands of newbie investors, thousands of experienced investors in the residential space, no doubt commercial as well. What's like, if someone was, let's say I don't know anything about property, and I ring you up, Ritchie, and be like, I need some help. I don't know how to go about this, or, what should I be thinking about? What questions should I even be asking you as my conveyancer. What's like advice you have? What's sort of some points perhaps that you would give to brand new investors, just to kind of get them up to a level of knowledge where they're actually being able to manage their team, i.e. manage their conveyancer?
Yeah, well, you obviously need a good team around you. And it's the buyer's responsibility to choose that team wisely. But ideally, well, I mean, what we do, we use a online platform called Rundle, which means that the client doesn't necessarily need to manage their team as much, because we invite their team in to Rundle. So, our clients will have their mortgage broker involved. They might, might have a buyer's agent, maybe not your clients, but the real estate agent might be involved as well. So there's they're involved in the transaction, so they've got the transparency of what's going on, and that saves the buyer from having to manage and then contact everyone separately. So they all know what's going on, and that makes the whole process a lot smoother. Of course, there's still barriers in place. For example, with the sales agent, if we're communicating, giving advice to our client and their professionals, there's some things that aren't relevant to the sales agent, so we have barriers in place for that. But ultimately, we want to make sure that everyone knows where things are at, that things are done by the due dates, and that just makes the whole process a lot easier for property investors. And they've got the comfort that everyone's on the same page and knows what's happening.
Brilliant. No, I think that platform is really good, actually. I've had a lot of good feedback. I think it's a lot of conveyancers are going that way, but I think perhaps you were one of the first, or it's definitely comprehensive. So it's it's a good innovation.
Yeah, I mean, and investors need to realize that. I mean, all the exciting stuff is done, right? Once you've signed a contract, but there is this legal process to go through, which is often parallel to the finance process. And there's, there is stuff that needs to be done. So they need to engage, even if it's just signing documents or confirming instructions. And a lot of the stuff is time critical. So, if you haven't given instructions to your lawyer about waiving a due diligence clause or a finance clause, if you haven't done that before the due date, you may lose your right to terminate the contract under due diligence, or the contract might be, in some jurisdictions, deemed to be the finance condition might be deemed to be satisfied, which means that if you end up don't getting finance, it's too late. You can't pull out the contract. So yeah, when your lawyer asks for instructions, it's really important to provide those as soon as possible. And if for whatever reason you can't, or you need more time to make a decision, that's fine. As long as we know in advance, then we can ask for extensions to those due dates.
Yeah, right. And I don't think, for anyone who's watching or listening, I don't think this needs to be like a stressful process. Like, I know Richie's talking about a lot of different concepts, and maybe some of them are going over our heads. But honestly, it's not, from a process perspective, it's not that difficult. And in fact, all good lawyers or conveyancers will actually probably send you like a sheet, or at least have somewhere with all the key dates on it. So as long as you calendarize them and you don't just like space out, what's coming up. Like, just before you put an offer in for the property on contract, send it off to the conveyancer, get them to check it out like we've been discussing. Once you get it under contract, let the conveyancer know. Don't just assume that the agent has let them know. Let them know.
Absolutely.
Yourself as well. And then let them know when you're getting your finance done. So it's just a case of like connecting your broker with your conveyancer, or if you could just be the middleman, it's not that hard. And then same with the building and pest, you're calling up building and pest person, getting that report done. As soon as you receive that report and had a chat with the building and pest person to make sure you understand the report, once again, just email your conveyancer and said, I'm all good with the building and pest. Mortgage broker confirms finance is done. Email your conveyancer. Yep, finance is done. The conveyancer will then email the seller's conveyancer. You go unconditional. So it's like, there's no need to be daunted by the whole process. It's pretty simple, but it's so essential to have a really good solicitor or conveyancer in case things go wrong. And then, of course, they're kind of holding your hand through the process because they're the experts. So was that a fair summary? Of course,
yeah. And I mean, you mentioned paper and emails, and we even remove that sort
Yeah,
of
use your
stuff.
Rundle
Yeah,
system.
we use
Yeah.
and we have little 60-second videos at key stages in the process, in the journey, because we know people don't like to read long-winded lawyers' letters, and usually don't. So yeah, we just sort of summarize it in a easy to understand video at key stages, so they know what's happening next. So, and rather than saying, okay, you need to do, this is all the stuff you need to do for the whole transaction, and a transaction can take anywhere from 30 days to 90 days, depending on jurisdiction, and longer if they're buying off the plan. So we let them know when they need to know about what they need to do. But most stuff can be done digitally, whether it's signing stuff by DocuSign, even verification identity, which is, there are really strict requirements that have come in the last few years. And there are a few alternatives, but we've got a system where they can do it using their mobile. They essentially take a selfie and then take a photo of your passport and driver's license, then nominate someone to do the same. Mm-hmm. And that comes back to us, and that satisfies the highest threshold of verification identity. So rather than having to go to your lawyer's office or having to go to the Australia Post Office, you can just do it after work at home.
Yeah.
So there's little things like that can make the process a lot easier.
Yeah, no, totally. It's 2023, and I think, yeah, maybe emails are archaic. I don't know. But yeah, you certainly don't need paperwork and all that sort of thing. So I will leave link below to Lawlab's link, and you can kind of check out their Rundle system and what they're all about. But just before we wrap up, Ritchie, was there anything else that you wanted to mention? Any last words of advice for any investors out there?
Not particularly, no. But yeah, thanks for having me. And your listeners can feel free to reach out to me or the Lawlab team. We're always happy to help. I guess the final piece of advice is, it's always better to get a contract reviewed before you sign anything. And most lawyers can turn that around pretty quickly. So get that done before you do sign the dotted line.
Okay, great advice. Thank you so much, Ritchie, for making time. It's really cool of you. And thank you for watching or listening. If you have, once again, I'll leave a link below to Lawlab's website, and you can go through that and check out what they're all about. Of course, there's lots of great lawyers and conveyancers and solicitors out there, but Ritchie's obviously right up at the top end of that. So go check them out. And thank you so much. I'll see you next week. See you later, guys.
No worries. Thanks, PK. Cheers.
Thanks, Ritchie.